So maybe we just matters and have a whole thing to do.
Where'd he go?
He wants to go use the restroom.
Right.
Nicely not the youngest person in the room.
Here it is. Here it is.
I'm what?
The youngest person in the room.
I'm what?
Are you the youngest person in the room?
I don't know. Am I?
Yes. Yes. Absolutely.
Josh
probably is.
Not Josh. You're an old man. I'm an old man.
Okay. This time, I'll call the meeting to order. At this time, the time is set for the continuance of the public hearing opened on April
Actually,
20th.
excuse me, Mr. Chair.
Yeah.
Were we gonna do the other items on the agenda later or?
Well, can I have the agenda? I would love to have the agenda.
We or your Gemini crap.
Sorry about that.
Is that the only thing I didn't read?
We'll start over. Okay, call the meeting to order, director's report.
Thank you, Mr. Chair, Commissioners. Just a few things that I'd like to update you on, some projects that we've been working on. After an unexpected delay, the Odell Unincorporated Community Project has started. We anticipate that our first advisory committee which includes the Planning Commission, will happen sometime probably late August. And these dates are all tentative. While our initial community open house will likely be held sometime around September. In the meantime, we're working on the project and trying to make as much progress as we can. We're also preparing a community survey for community input and as well as working with the next door to complete some additional community outreach. As anticipated, FEMA provided the county with a letter of final determination earlier this month concerning their updated flood hazard maps, which starts a 6-month clock for us to get the maps adopted. And, you know, this 6-month adoption process comes with the threat of the county losing its flood insurance program or having it suspended if we don't meet it. So it's obviously a very high priority for our department. As you may be aware, the Gorge Commission recently made changes to the management plan concerning rules involving replacing structures that are destroyed by natural disasters. And this is in response to the wildfires that happened in Wasco and Klickitat counties last summer. And in compliance with the National Scenic Area Act, the county has 270 days with which to adopt those changes into our local code. And so we are working on that as well, and we'll have a work session on that probably in the next couple of months. Finally, I have some news, although it's not necessarily good news to share concerning the draft accessory dwelling units ordinance that we brought before you during a work session last fall. Unfortunately, our consultant who we've been working with let us know recently that she had to withdraw from our contract due to some family health issues, and so she's no longer able to assist us. And so unfortunately, because of that, and because of the priority projects that I mentioned, I'm less confident that we'll be able to make a lot of progress on that ordinance anytime soon. And so as far as upcoming meetings at this point, there's nothing on the schedule for June, but we do anticipate having items for you in July. That's all I have to report.
And we have Chris with us tonight.
We do.
Chris, do you have anything?
I do not have anything to add. Thank you, Mr. Chair.
Okay. Did everybody get a chance to read the minutes from April 22nd? Are there any changes? Is there a motion to approve the minutes?
I'd like to make a motion to approve the minutes as read.
Is there a second? Second. All those in favor say aye.
Aye.
Any unscheduled items from the general public? Any unscheduled items from the commissioners? This is a public hearing. The planning commission will continue the appeal hearing from April 22nd to consider the appeal filed by Thrive Hood River of the Hood River County Planning Department's tentative approval for the application of an industrial land use permit. The permit would allow the construction of approximately 48,960 square foot warehouse and distribution center. No additional testimony will be accepted at this hearing. The planning commission may ask clarifying yes or no questions. And questions deliberate and then make a decision. This hearing was continued after the request pursuant to ORS 197797 to keep the hearing open for 3 consecutive 7-day continuous periods for additional written testimony and rebuttal to be approved. No additional evidence or testimony will be allowed during tonight's proceedings unless the commission makes a motion and votes to reopen the record of this application. The commissioners will, if necessary, ask clarifying questions of staff, counsel, the appellant, the applicant, the appellant, or possibly others. Closing the hearing and deliberating over the evidence and testimony in the record and make a decision. Is this agreeable? Does anyone have any ex parte contact of significant nature to declare in this matter since the last meeting? No. Is there anyone in the audience who wishes to challenge the qualifications of any member of this commission? Staff or county council will do what they will do. Do you have any more to add to this before we get started?
Nothing more.
Okay. Commissioners, do you have any clarifying questions?
No questions.
Commissioner Moore?
No questions.
Commissioner Guisto?
No question.
Commissioner Lyman?
No questions.
Commissioner
No
Garrett? Commissioner Kitts?
questions.
Okay. So this time we can close. Okay, at this time we'll close the hearing and then initiate commissioners' deliberations and decisions. We'll start with Commissioner Lewis to deliberate. You don't have anything? No. Fine. Commissioner Moore?
I go back to, hearing all the testimony at the last hearing and then also the follow-ups that everybody was providing with during the additional comment periods and then the final rebuttal from the applicant. And I still just come back to the original House Bill 2691 was passed in 2003. That was ironically co-sponsored by both Patty Smith, Republican representing Hood River County, and Senator Rick Metzger, the Democrat representing Hood River County, to allow for these mill sites to be reclaimed under Oregon's land use laws for industrial lands. And so I struggle with, the issue of reusing those lands, going through that process, it being, originated from the upper valley of Hood River to reclaim those lands and then to go against anything that we would be able to deny somebody, especially where we've already allowed it in the past with much larger footprints and much larger impacts. It's more of a statement thing.
Commissioner Guisto?
Yeah, I don't disagree with what Commissioner Moore said. Based on the last meeting with the public testimony, it's always great to hear from the community, and I felt like everyone came in with such differing perspectives. Many I wasn't considering that would come in, and as much as I feel, or I appreciate all of those viewpoints and those opinions, it's really difficult to lean away from the land use law and what the planning department has done here. the traffic study was brought up many, many times. And there is talk about whether that was satisfactory or not, and we have opinions on whether it was or wasn't. But if ODOT is approving that and the county is approving what ODOT is saying, I don't think it's our position to tell ODOT what to do. Unfortunately, in some instances, I feel like it could have been an expanded study. They could have done different days or different times of the year that maybe would have represented our community better. And I think we would have all appreciated that a little bit more. However, that isn't the way that it was done, and it was approved by ODOT regardless. And going back to the old mill site, and the land use laws and the way they were changed and the way they are meant to be, and the footprint that they're asking is much smaller than what others are doing in the same area. I'm not seeing a lot of space for movement here.
Thank you. Commissioner Lemon?
I was and have been very moved by the number of folks commenting with deeply held concerns about this proposed development. Some of the concerns relate to Amazon's business practices, which we cannot entertain in this kind of a setting. Whether we agree with them or not, it's not our job to evaluate that. Some of them, most of them dealt with concern about traffic, and that is an area where the county does have within their ordinance the requirement that the applicant make the case that they're not creating a traffic, causing dangerous intersections or traffic congestion. The way that was done in this case was the ODOT and the County Public Works defined what the traffic impacts analysis should include. And it was done professionally by a competent engineer, and ODOT approved it. The one thing that stands out to me, though, is that methodology that ODOT requested is the same that is used whether you're in Brookings or Enterprise or in Ontario or Beaverton. It's all based on midweek during the school year, AM and PM peak. And I know that because that was my business for almost 40 years. We have, as a county, the ability to go beyond that to make ourselves comfortable that the access will not cause dangerous intersections or traffic congestion. And I would like to see a request to the applicant to evaluate 2 specific periods. A period during the harvest time, when you've got a lot of trucks on the road and a lot of visitors stopping on the Fruit Loop, and also during the ski season, to find a peak time there and see how that would factor in. If we can do that, I appreciate what Commissioner Justa said. The ball has, we've gone down that road. ODOT has approved a traffic study that did not consider that. But if we have the opportunity, I would like to go back to honor the concerns of our community and say, look at these 2 additional periods before a final decision is made. If we can do that, and I don't know whether procedurally we can do that. I haven't spoken to Eric or anybody, but if I could have my preferences, I would approve the staff approval of the project contingent on a further study that addressed what I just said. So I would look for guidance from county council or staff, whether that's a feasible path.
Just so I understand the question, are you looking for a condition of approval that says that you would provide this expanded traffic analysis concerning these two additional factors?
Yes,
As opposed to saying, I would like to, before we make a decision, I would like to have the appellant or the applicant provide that information. You're saying the former?
it would be fine with me to have it as a condition of approval, as long as that follow-up study was made public so that everybody who has expressed concern about those conditions could see what the result was. Are we tripping over anything?
Not
then?
necessarily. I mean, I think the option of adding a condition to the permit is definitely within the commission's purview. I would rather that approach than the second approach,
To
because
wait.
then it reopens things up and there's other challenges that go along with that. So I guess I would maybe turn to county council and just see if
Yeah.
any other factors that we should be considering if that ends up being a path they want to take.
Thank you, Eric. I hope everybody can hear me. I'm Chris Crane, the County Counsel for Land Use tonight. I guess two issues I have. The first is there an approval standard we can point to say it's not met without this condition? If it's not met, then obviously you could deny the application. So does this condition implement one of the approval standards without which we couldn't conclude the application can be approved? So the first concern, we need to tie it to an approval standard. The second concern is, what do we do with the information in this additional traffic study when it comes back? Is it a condition of the permit? You said the approval was contingent upon them. I'm not sure I understand what is supposed to happen depending on what the report says.
Matt?
Yes.
To your first point, Chris, I would suggest that in our ordinance 3160, it says site access will not cause dangerous intersections or traffic congestions. We can suggest or state that the information we have is conventional but not conclusive as it regards to the particular conditions in this county, and argue for a little bit more information. That would be the way I would try to interpret that. The second point would be if they come back with this additional study and it shows conditions that are dangerous or creating traffic congestion, then there would have to be some kind of mitigation associated with that.
Okay. We may need to discuss what that mitigation looks like. On the other hand, Eric had some suggestions for how it might be handled administratively through permitting that may help us through this.
Yeah, it may get a little challenging just because you have this condition of approval that requires submitting of this information. At what point is a decision made that it either complies or doesn't comply? And is that discretionary, and is that subject to review and approval or appeal, I should say? So that, puts us in a little bit of an awkward position, because if we have an approved decision and now we're making kind of a follow-up decision based on an unknown.
Yeah, well, I appreciate that, and I recognize I may be asking for something that bollocks is up the work, to use a technical term, and I don't want to do that. I do believe the applicant has in good faith provided everything they were asked to provide. If we can gracefully do it, I believe it's a tool that will show good faith to the community at large to say, we heard your concerns and we're trying to address them. If it screws up the works, then I will accept it. It's not a path forward we can take at this time.
And Chris, do you have any additional thoughts as far as the practicality or the function of how we decide whether the condition is met? Are we bound by, are we able to say that it's been met or not met without providing opportunity for an appeal of that decision?
Before you make a final decision, you do have to give the applicant an opportunity to propose conditions that might bring it into compliance, the application into compliance. You have to give them that opportunity before you can make a final decision if you're going to deny on that basis.
Is that in regards to tonight's decision?
If it's the county's final decision on the application, yes. The applicant has to, before you make a final decision to deny an application, the statute says you have to give the applicant an opportunity to amend the application and hopefully bring it into compliance.
I think what we're talking about, Chris, is an approval subject to a condition. So it's not,
Condition, yeah.
what's that?
The law on that says you can do it, but only where the condition is reasonably obtainable. And here, without knowing what standard we're looking for, what is likely to, there's no, I mean, I think the traffic study that you're talking about is a black box. If it comes back and says this, then there's one result. If it comes back and says something else, there's a different result. Can we plausibly say that the applicant, there's a reasonable means for the applicant to meet the criteria? And if so, then you can add that condition. But you can't set impossible standards and say you didn't meet it. And the problem with a black box condition like this is it's hard to know whether it can be met or not. Speculation.
I think that therein lies the challenge from a practical standpoint of how we actually implement something like that is typically you're making a decision based on have they met the criteria or have they not met the criteria, or if they haven't, can it be met through a condition? And it seems difficult to be able to say, you know, we're approving your application subject to this condition that is probably going to require, and maybe there's a way to word it in a way that, you know, subject to ODOT, you know, reapproval, but ODOT has already approved it. And so I'm just not sure of how to implement it in a way that results in they've either met it or they haven't met it, black and white, no discretion.
Can we like come back to this? Because I think some of the points that I've written down might address some of the,
For sure.
so that's helpful.
Anything else? Mr. Garrett?
I took one from Commissioner Moore's book a couple sessions ago, and I wrote my stuff down because I've been rereading all the testimony all day, and so kind of got it into a couple of sections. The first part, I just want to addresses some public concern. I want to address consistency in interpretation. I want to address term site access. And then I want to talk about the traffic study. And I think we're going to touch on some of Commissioner Lyman's topics that he discussed. So the first part, this is for the general public. This is a really unique application, and it involves modern fulfillment and logistics operations that we don't really contemplate by our older code language. Our task is to apply the current code standards as written and to determine if the applicant has demonstrated compliance based on the evidentiary record before it. So the stuff that we've all had testimony from you guys, that's the evidentiary record. We have to apply our own existing current code to that. We can't change it. The county even acknowledges that this online retailer is kind of an unusual position, and it doesn't fit neatly within our code. That being said, tonight we have to apply the code as it exists and it is written. The applicant, so consistency and interpretation, the applicant has argued that throughout this proceeding, the term wholesale is used in the code should be interpreted broadly enough to encompass an online retail fulfillment operation that by any conventional understanding looks and functions quite differently from traditional wholesale distribution. This is not a reading the applicant invented. The county itself, in its April 28th memorandum, reaffirmed that denying the proposed facility on a narrow view of wholesale would set a precedent that would limit new business and acknowledge that the county's historically broad interpretation of wholesale. The applicant accepted this position and incorporated that into their May 13th rebuttal. This broad interpretation of wholesale is therefore not just the applicant's argument, it's the county's stated position. It's been affirmed, it's on the record, and it's been accepted by all the parties. This is not a contested interpretive question. It is the established interpretive framework within which this application has been evaluated. Having secured the benefit of that broad interpretation to establish the use is permitted in this zone at all, the applicant is now asking the commission to read that site access should be read narrowly, and it's confined to the driveway connection alone and nothing more. So if wholesale is broad enough, and the county has formally confirmed that a broad reading is okay, if wholesale is broad enough to encompass a modern e-commerce fulfillment operation with its associated logistics, traffic, truck movements, and delivery infrastructure, then site access is broad enough to encompass the transportation network's impacts that operation generates. Interpretive breadth should not be selectively applied. Generous when it benefits the applicant's side for permitted use status, restrictive when it might require meaningful traffic analysis. Consistency in the statutory construction is not merely a logical preference, it's a fundamental principle of our code interpretation. An applicant who has benefited from a broad reading of one provision cannot credibly demand a narrow reading of another in the same proceeding. To accept that inconsistency would allow the applicant to use the interpretive framework to their advantage whenever they would like, which is precisely what the requirement of consistent principled interpretation is designed to prevent. I find that the same interpretive approach that justified this finding this use permitted under wholesale, a reading informally affirmed by the county on April 28th, which looks at function, purpose, and real-world operation rather than a narrow textual literalism, must equally govern this interpretation of section 31.60A. A broad reading of wholesale demands a broad reading of site access. The traffic analysis must reflect the actual network level impacts of the use as it will actually operate. So talking about site access and network level analysis. So I'm going to reread section 31.6. A site will not, at the time of a new development or change of use, the applicant shall demonstrate. Shall is a command. They are required to demonstrate proof that whatever is below this is met. A, site access will not cause dangerous intersections or traffic congestion. They will have adequate visibility for motorists and pedestrians and will be kept at the minimum needed for safe ingress and egress. Roadway capacity, speed limits, and number of turning movements shall be considered. That's from our code. That's not from ODOT. So this section 31.6 is up to county interpretation and not ODOT standards. Okay. Thanks for bearing with me here. Okay, so going back to that, section 31.6A provides that site access will not cause dangerous intersections or traffic congestion. It further requires consideration of roadway capacity, speed limits, and number of turning movements. The code does not expressly limit this inquiry to immediate driveway connection or parcel frontage. To the contrary, the factors specifically identified in the provision, roadway capacity, traffic congestion, and turning movements are transportation system concepts that extend beyond the driveway throat, where the project-generated traffic materially affects nearby intersections or roadway segments. I interpret site access in functional terms. It encompasses the relationship between development and the transportation network through which project traffic is distributed. This interpretation gives operative effect to all portions of section 31.6A and is consistent with the public safety purposes and the provision serves. It is also consistent with the applicant's own stated interpretive methodology. In the May 13th final rebuttal, the applicant states, words cannot be considered in isolation without consideration to context. These other words are important as they provide additional information for discerning the county's intent. That was on page 5 by Bateman and Seidel. Site access is no different. Its meaning is informed by the consequences the provision is designed to prevent, the factors it requires to be considered and the public safety purpose that it serves. So if we're talking about the purpose of that code, it's the intent. It's not necessarily about the immediate surrounding areas. The purpose is to ensure public safety. I am not persuaded that section 31.6A compels a driveway-only interpretation. The applicant argues that site access limits this inquiry to the driveway connection alone. I find that argument unpersuasive for several reasons. On May 7th, May 13th, page 7 of the May 13th rebuttal, the applicant states that opponent's approach improperly omits the qualifier directing this inquiry entirely to site access alone. And it's really tricky. They put in a word there that's not in the code to make it sound like it's in the code. So they put in entirely next to site access to show that we can only look at site access alone, like immediate site access. Site number 2, site access in this sentence identifies the cause of the prohibited conditions and is not a geographic boundary of the inquiry. Site access is the subject that generates the trips, and those trips cause congestion. The causal chain does not stop at the property line. The applicant's own interpretive methodology compels this broader reading. On page 6 of the final rebuttal, the applicant states that opponent's arguments are not supported by the text of the code considered within its context. Applying that same principle here, reading site access in the context of the consequences, it must not cause the network level factors the provision requires to be considered, supports the broader reading. The applicant cannot invoke contextual interpretation when construing wholesale and then abandon it construing site access. Under the driveway only reading, the provisions express references to traffic congestion, roadway capacity, and turning movements would have limited independent meaning beyond the matters already addressed through ordinary driveway geometry and site distance review. This interpretation would render express code language superfluous, which code doesn't like to do. And then I think this is important. The interpretation needs only to be plausible and consistent with express language of provision. It doesn't have to be the only possible reading. So my reading of the broader interpretation might be different than the applicant's, but I think that it's a plausible, logical, and it is consistent with the express language of the code. On the adequacy of the traffic study, I appreciate that they brought in a traffic engineer. The submitted traffic impact study acknowledges that ODOT requested the analysis of, I think it was 3 intersections in connection with state access permitting. Public testimony and evidence submitted during this proceeding raised concerns regarding the downstream congestion and safety impacts at additional intersections and roadway segments not included within the applicant's analysis. That evidence and testimony was sufficient to place the adequacy of the study's geographic scope squarely before us. Staff's approval did not meaningfully address whether those additional intersections should have been evaluated under section 31.6A. While Highway 35 is subject to ODOT access management review, the scope of ODOT's review does not necessarily determine the scope of analysis required under the county's separate local approval standards. ODOT's 3 intersection scope defines the minimum necessary for state access permitting purposes. Does not define the ceiling of what section 31.6A requires. The state access permit process and section 31.6A serve related but distinct regulatory purposes, and an applicant cannot satisfy a local public safety standard simply by pointing to a state agency's separate and more limited review. So just because my reading of this, just because ODOT approved it, doesn't mean the county has the same approval standards. The record contains photographic and video evidence submitted on April 30th, showing existing congestion conditions at downstream locations outside the study area. A reasonable person reviewing that evidence would conclude that additional traffic from the proposed development could worsen these conditions. The applicant has not demonstrated that the project will not make things worse at these locations. And that burden of demonstration rests with the applicant under section 31.60A. Portions of the applicant's traffic distribution assumptions were characterized as proprietary during this proceeding. And that was brought up in the April 22nd meeting. Because those traffic distribution assumptions were not fully disclosed in the record, I don't think we're able to accurately evaluate whether the downstream intersections receiving project-generated traffic were adequately analyzed under this section. The burden of demonstrating compliance rests with the applicant. That burden cannot be met where the data necessary to evaluate compliance has not been made available to the decision maker. I also find that there are unresolved questions regarding whether the selected September traffic study reflects the representative higher volume seasonal conditions for both baseline Highway 35 traffic, as well as the proposed operation. The current record does not sufficiently address whether the submitted study reflects reasonably foreseeable peak operating conditions relative to evaluating congestion and roadway capacity impacts under section 31.6A. A study conducted during a non-peak period cannot demonstrate compliance with a standard that requires site access, not causing congestion or dangerous intersections. Dangerous intersections and congestions may only manifest themselves during peak seasons. And then finally, under section 31.6A, the burden rests with the applicant to demonstrate that site access will not cause dangerous intersections or traffic congestion. Staff's approval did not adequately address the concerns raised in the record regarding geographic scope, traffic distribution, or seasonal conditions. Based on the present record, I'm not satisfied that sufficient evidence has been provided to support the findings required under section 31.6A regarding congestion, roadway capacity, dangerous intersections, and turning movements at nearby intersections and roadway segments materially affected by the project generated traffic. So thanks for getting me started. I kind of see two paths forward. Not appropriate for the those here to clap for that. It's a tough job. So I feel like there's two paths forward. One is we can sustain the appeal and request more analysis. The other path is we can accept the appeal and make them go back to the drawing board and get more of traffic analysis. I don't believe that the burden of proof has been met. That's all I got.
Commissioner Gibbs?
All right, I agree with pretty much all of that. And then I would just like to add that, yeah, also thank you, public. That was great, all the testimony. I feel like part of what we're here to do is to implement the Oregon statewide plan and goals. That's like what this committee's kind of for. And I think there's at least four that this facility goes against. Goal 3, agricultural lands. Goal 8, recreational needs. Goal 9, economy of the state. And Goal 12, transportation. I think they're like, they do not group together. And I can read the description of each goal if you guys want. So it says, Goal 3, agricultural lands requires county to reserve and maintain ag lands. And I think that traffic, especially during the peak times, is gonna be a problem for the semi trucks with all the fruit and like tractors and stuff. I think that's gonna be problematic. And then the recreational needs, Goal 8. Local, state, and federal agencies in the private sector must coordinate their plans for recreational facilities and activities to protect our recreation resources and help nearby communities prepare to meet the demands these recreation destinations place on public services and facilities such as roads. So that's pretty straightforward. And Goal 9's economy of the state calls for the diversification and improvement of the economy. It asks for communities to protect future needs for commercial and industrial lands and plan and zone enough land to meet those needs. So in that, I don't think that's really our purview to like choose what business goes there, but we can think about what that industrial use might be better for. And then Goal 12 is like what we've talked about this whole time, transportation. The goal aims to provide a safe and convenient and economic transportation system. Yeah, that's my 2 cents.
Anybody have anything else?
I'd like to keep one more point on the
Sure.
traffic study. I mean, this is a complicated issue. I think for me, it does. The broad interpretation of wholesale falling under industrial is fine. That fits within the existing framework of our code. I think if you take that broad interpretation, like I mentioned, you have to take a similar broad interpretation of site access. And site access, if you're just looking at the immediate, what's immediately adjacent, doesn't take into account the broader context. As the applicant mentioned, you have to take in the broader context. And I think we need to do that when we're looking at this. A couple things that did stand out on the traffic study. We look at peak volume for the applicant. In the AM, it's between, I think they say, the peak truck volume is between 9 and 11, and the PM it's 8 to 9 or 7 to 10, 8. I can't remember what that exact timing is, but they look at peak hours in the morning and the evening that are different than those. So we took 2 samplings on one day of hours that aren't even associated with when the trucks are leaving. And I find that very problematic. And when it comes to a burden of proof, again, it's on the applicant. I don't see where that burden of proof has been met. I think that they have done a great job of bringing in professionals, but I think in my interpretation of our local zoning code, which I believe we are allowed to interpret where there isn't a definition available, that site access should be a broad interpretation. And if you use that, you have a broad interpretation of site access, then we should be able to ask for more assessment of downstream impacts that might happen seasonally. Professor or Commissioner Lyman, I'd take it further. I'd say it's more than just 2 times per year. It's not just agricultural and ski season. It's probably midsummer when we have peak winery tourism as well.
Mhm.
So those are my 2 cents.
Do we have anything else?
Can I
Commissioner
ask
Moore?
a question? So based on that, John, I was just trying to figure out how this would work, Commissioner. So if we were, because if we apply this to one, we have to apply this to all future businesses going forward. So if anybody submits an application for industrial with traffic kind of things, we're gonna require them to do a full year-round study.
Well, I think that's because it's not defined in the code. I think that's part of where the interpretation of our own local code is appropriate. Not all, you have to take into context, right? Not all applications are equal. And my read is that that is something that the planning staff or commission can require or can request.
Okay.
Yeah, like not all industrial uses are gonna have this same amount of.
And part of the reason that this is not done is because there has been public testimony which has entered into the record areas that already have congestion. If hypothetically, if somebody were building in the exact same spot that didn't create traffic impacts that were brought to the planning commission's table, we wouldn't be talking about it. But because that was brought in as evidence, I think we can assess that.
Okay. And would this open us up for equal protection clause issues in the future?
That is a
Lawsuits?
question for Chris.
Yeah. Thank you, Mr. Chair, Commissioner. No, you do have the ability to interpret your code. You should always strive for consistency, but every situation is different. If the similar property presented a similar development project with similar zoning, you obviously would presumably interpret it the same way, but circumstances are different. The other thing is a subsequent council could conclude that you guys misinterpreted that code section and interpret it differently. It's not really binding, and to the extent it is, it's only binding on this board and not subsequent boards. So I'm not terribly concerned about any kind of equal protection arguments. You have broad discretion to interpret your code how you think it should be interpreted, provided you're not constrained by state law or a definition elsewhere in the code. And subsequent boards may interpret it differently. That's their prerogative.
I think that's an important point too, is that if you read through it, I was reading through it again today. Some of the things that were approved in 2018 that were clearly online retail probably didn't quite fit the box, but they were not under our purview on the planning commission. So it is different. It's use the word regime, but different regimes might interpret things differently, and that's part of the beauty of planning commission.
So back to the two recommendations that you proposed, Commissioner Gary. We talked about one with conditions. Can you read the one?
So here's what I wrote down.
And also, Mr. Commissioner.
I don't know if these are the right path forward, but I can't. My interpretation of site what was that called? Site access needs to be broad. So this is where I got to. So my two paths forward were that the commission can sustain the appeal in part and continue the matter, returning the application to staff with discretion to require supplemental traffic analysis that addresses the downstream intersections receiving material project traffic, reflects peak seasonal conditions, and includes the traffic distribution data necessary to evaluate network level impacts. No approval shall be issued until that supplemental analysis has been reviewed by the commission and is satisfied that the requirements of 31.6A have been addressed. So that's option one. Or two, the commission sustains the appeal and denies the application on the grounds that the applicant has failed to meet the burden of proof under section 31.6A. And that the submitted traffic impact study does not address the intersections of roadway segments material to evaluating whether site access will cause dangerous intersections or traffic congestion, as that standard is properly interpreted and the record does not contain substantial evidence of compliance. So those are two paths that I wrote down. I don't know if there's probably other paths. So
Commissioner Lemon, did you have something else you wanted to?
Regarding Commissioner Moore's comment about, impacts to future work, I think if we word it such that we ask the applicant to identify peak periods for traffic that might be affected by their development and have them define the peak periods. And we know from public testimony that there are at least two peak periods that are concerned, and Commissioner Garrick introduced a third peak period. So if we just ask or require the applicant to evaluate data from ODOT, which is available basically on a daily basis for the year, and identify peak periods. Put the burden on the applicant to identify the peak periods and then evaluate whether their traffic will create dangerous intersections or traffic congestion in the specific language of section 31.6.
I think one thing that I would like to build on that is that it's not just about peak traffic on Highway 35 from us, tourists and agriculture. It's also peak traffic created by the applicant. On the 513 rebuttal, they talk about, or maybe it was the one before that, the traffic study references the seasonal impacts from mid-November through December is 33 to 50% higher than what they put in the traffic study. And if we accept, in my interpretation of our county code, if we accept less than that, then we're saying it's okay that for 6 weeks out of the year, 7 weeks out of the year, we potentially might have dangerous intersections. And I'm not okay with that. So I think you would also have to look at the maximum proposed impact from the applicant during their peak seasons as well. So take peak and put them together and see what traffic analysis comes up with.
I agree with that.
Anybody else, anything?
So we would expect them to represent their peak period in that calculation. We're gonna ask them what their peak period is, and we're gonna accept whatever they give us. I mean, that's kind of,
I think
we're asking for a number.
Well, yeah, I mean, they give us a number and they admitted, the applicant stated that their peak numbers are, take the high numbers, 50% higher. I think our code gives us the bandwidth to say we're not just looking at average. ODOT says one thing, and that's great. ODOT has their own program, but the county code is specific. So I think we can't prove any more than what they tell us. But if they already stated it's 50% higher than what they showed us, I think we should look at that. I mean, that's you know, it's fair, it's reasonable. I think it's possible. A reasonable person would think that's logical.
More?
Anybody else have anything?
Do we have a motion?
And I'd like to have a little bit more discussion about the options. Oh, go ahead.
Well, that's, yeah,
Rather than a motion first. Yeah.
I just asked you that, and you didn't say anything.
About
No, I just asked you if you wanted to say
Okay,
anything.
here as it said.
Well, I mean, to me, there were so many deficiencies in the traffic study. And I truly appreciate all the work you put into finding the path for us. Finding this path for us, so I appreciate that. But if you're telling the applicant to go on their own, go make it better, like go find the peak days you've heard from us, like go make it better. And then they come back and we're like, just kind of half satisfied. I don't know if we need to, like, there needs to be conditions, like, for, I mean, if we get the choice, I mean, it would be nice to see traffic going through Odell because they were very blindsided in north and south.
Yeah.
And that was, that was concerning. And they took into account that there was school hours, but they didn't take into account that there's a school like a mile away from the facility that a lot of those trucks are going to be driving by.
I think you raised a really good point. I think we should put some, we are the experts of our local area. And I think and there's lots of areas referenced in the testimony.
Right.
And maybe that's the best starting point, is using the areas referenced in the testimony of additional site access impacts. Rather than.
And like you say, downstream, like the Burke Hill for Mountain intersection, that's right down there where you're gonna have Packers and then down into, all the intersections to the north there.
And then the video that drove from the China Gorge intersection southbound, I think is a great starting point for a required traffic impact analysis. Because that is in the evidence already.
Yeah, I guess that's a question on how we formulate the requirements of the future traffic study.
Maybe it's a question for council.
Mr. Levin?
I believe one further point is important, and Commissioner Garrick, you make the distinction between what's required for an ODOT study and what we want for the county, which is totally accurate, but we need to have a standard by which we measure any further study. And that has to go back to ODOT level of service standards on the highway. And I don't know honestly whether the county public works has level of service standards on the county roads. But there has to be a standard by which we tell them they have to pass or fail.
That's a very good point. Odell Highway is a state highway, right?
Yes.
So that would fall under ODOT.
Yes, exactly.
That's amazing.
Yeah.
But good, great point.
If I may comment on the procedures briefly, it sounds like folks may be starting to circle around some suggestions for moving this forward. I want to make sure we get the procedure correct. As I understand it, there's concern that there's not sufficient information in the record to determine that section 31.60 site access standards have been met. The discussion then goes on to requiring an additional traffic study to cover other periods. And presumably what that traffic study, what you would ask the applicant to show in that traffic study, which is what I was just hearing. So if that's how folks want to move forward, it seems to me there are two paths forward very similar to what was suggested earlier. If the applicant is open to it, we can ask them to provide that additional information, continue the hearing, and when it comes back, reopen the record on that issue so other people can comment on it as well. Then you close the record and make your decision. But at that point, you would have the information, presumably, that would demonstrate their compliance or failure to comply with 3160. If you wanted to reach that conclusion tonight, that the application doesn't meet that standard because the traffic study is just not reliable enough, or however you want to characterize it, you could deny, but you first have to give the applicant an opportunity to suggest or propose conditions that would bring the application into compliance with that standard. Whether they're prepared to do that tonight, I don't know. I don't know where we are with a 150-day deadline on this application, but those are basically, if you want to continue the hearing, continue the debate, discussion, set another hearing and ask for additional information. Or you can deny and see what conditions the applicant might be able to propose.
Chris, if we continue I guess the first question is from a legal LUBA perspective of those two options, which one does council?
I don't have enough information. I need to get some insight from Eric on this, on where we are in terms of deadlines. Do we have time to continue the hearing? We would need to hear from the applicant. If we don't have time, are they willing to extend the deadline? Once we have that information, then we'll know what I can tell you, have a better assessment of what the county's risk is if you continue the hearing. Because there is a legal deadline, 150 days or as far out as it's been extended by the applicant. I don't know how close we are to that deadline. And if we blow the deadline, they can just take it into circuit court. I would look to Eric, but I can't quite see him on the screen.
Chris, is there any reason on the opposite side? So we have denial or go back, extend. Is there approval with conditions, or is that back to where we were talking about? That doesn't work very well.
It doesn't exactly. Thank you. It doesn't work very well because presumably we would want the ability to act on whatever that study shows. If it shows there is no greater risk or danger at that site, then you could have approved it tonight. But what if it shows the opposite? What if it shows, the sky is falling kind of scenario? That might indicate that you shouldn't have approved it in the first place. So until you conclude that there's not enough evidence in the record period, or we find a way to get that information to you before you make a final decision.
Thank you.
Either way, we're not making a decision. Well, I guess that's
I'm sorry. I don't want to. I would be remiss if I didn't say you could also conclude, as by a majority of your membership, that there is enough evidence in the record that the majority interpretation of that code section is that it's met. So you could approve that tonight based on the information in the record. You can conclude that it's not met and deny it, or you can see if there's enough time to get additional information.
I guess that's the first hurdle. Is there enough time to get additional information? It seems like
No.
We're past the time frame already.
okay. So if that's the case, we're past the time frame and there's not time to get additional information. If we deny or if we accept the appeal, which denies the application, then it goes back to, it potentially can go back to staff for a reapplication with perhaps an additional traffic study.
I'm sorry, can you say that again? If
we choose to uphold the appeal and reject the application,
deny the application, okay,
then the applicant can go back to the county staff with the knowledge from this hearing and start the process over again with a revised traffic study.
That is correct.
That is
however,
okay.
Within the code, there is a requirement that if you are denied a request, you have to wait another year before you can reapply.
And so if we deny it, we would need to say, be a little bit specific in the denial, like this is the traffic study we feel like we didn't see.
I think you make a decision if you're inclined to deny the application, you deny the application. And then it gives an opportunity to appeal and to make those arguments at the board level. And then the board becomes the decision makers on whether they feel that the planning commission made an appropriate decision, and if they accept, all your information is part of the record, and they'll be privy to that, and they'll make a decision based on all the information in the record, including your deliberations.
And that's if we deny it tonight. Well, I don't know if you answer your notes. Power management. I guess, is there any other more discussion on that?
Don't say
We
anything.
can have more discussion after it's been.
Was there still the option for the applicant to allow an extended period of time if we ask them, or just because we're past the date, it doesn't?
We can certainly ask counsel.
I'm sorry, I was looking at something else. I need to withdraw something I said earlier. The requirement that you give the applicant the opportunity to impose conditions only applies to a residential application for housing, residential application. So that would not apply tonight. No, I'm sorry, what was the other question?
Does the opportunities, even though the 150 days has expired, does the opportunity to ask the applicant for extended period of time to get more information still exist?
Yes, you can. You can, if they're willing to do that. If not, the statute allows for something like a 14-day period after you make a final decision for us to get the findings written and have them signed and issued. But yes, I think that's a discussion you might want to have with the developer, who I see is on this in this meeting. Whether they're willing to extend or whether they would prefer just getting a final decision tonight.
Can we hear from the developer?
What are we extending?
Thank you, Chair and Board. My name is Carrie Richter. I'm the attorney representing the applicant. I appreciate the opportunity to respond to the question. Throughout this process, the applicant has responded to all of the testimony that has been received and done additional studies as opponents raised concerns. In the record, we provided the traffic study analysis that doubled the amount of traffic generated by this particular use and found that there was no failure. So I am not sure what additional evaluation you would want the applicant to do. I am open to extending the record to provide even more analysis, but as I believe I believe it was Commissioner Lyman said, we have to, the applicant is entitled to know exactly what intersections you would want the applicant to study. What is the threshold for deciding whether there is a dangerous intersection or there is congestion? They're entitled to know how you are going to interpret the standards so that they can produce the evidence consistent with your ask. So until I can't consent to extending the record until I have some additional information about the scope of what you're asking the applicant to produce.
Thank you.
So we're talking about having another meeting where we just figure out what intersections we want to include.
The applicant isn't in a position to accept an extension without our conditions. So, I mean, it kind of seems like to me like the cleanest thing is to deny it, and then they can appeal it to the board, and that we don't have to come up with the additional intersections and what those standards are. Because I think that puts us in a riskier position to determine that if it gets remanded to the Board of Commissioners, I feel like it's cleaner and we have less there's less interpretation on our side of what's a proper intersection.
Yes.
A procedural question, I guess, for staff, if we followed Commissioner Garrick's suggestion that we deny and expect that the applicant will appeal to the County Board of Commissioners, would they, in their deliberations, ask for additional information?
Could they, the board,
Would they, the board?
ask for additional information? Well, when the board hears the matter, it's gonna be on the record of the planning commission. They cannot ask for additional testimony or evidence without reopening the hearing. In the past, they have tried to avoid that scenario because it just kind of restarts the process over again and delays the process further. So certainly within their purview to do that, but it would have to happen through a procedural change of hearing the matter de novo as opposed to on the record of the plan.
So we're not gonna get any traffic study.
Well, that's what it sounds like. That if we deny and the county board takes up the matter without asking for additional information, there would be no further analysis.
That's correct.
Well, it's kind of our job, right? I mean, that's what,
Yeah.
that's our job is to do that. It's
They just kick it one checks again.
Is that what happens? They could take it back to us and it would restart.
It's in the realm of possibilities that they could remand it back to the planning commission, but my experience has been that that's not what they tend to do. They'll make a decision based on the record, and it'll be thumbs up, thumbs down decision.
I would like to make a motion to sustain the appeal of, that's the wrong sheet. Do you have the other sheet? No, I do. Can I see your sheet? Yeah. I would like to make an appeal to, or make a motion to sustain the appeal. Where's the number? Is there a number here? Oh. Filed by Thrive Hood River of the County Planning Department's tentative approval of an application of an industrial land use permit on the grounds that the applicant has failed to meet the burden of proof under section 31.6A. The submitted traffic impact study does not address intersections and roadway segments material to evaluating whether site access will cause dangerous intersections or traffic congestion. That standard is properly interpreted. The submitted traffic impact study does not address intersections and roadway segments material to evaluating whether site access will cause dangerous intersections or traffic congestion, as that standard is improperly interpreted, and the record does not contain substantial evidence of compliance.
Second. Okay. Any other discussion?
I just want to make a clarifying point that the 31.60 does not require a traffic study at all. And so that is an ODOT requirement, and the ODOT is the one that approved it. So how do we deal with that?
Perhaps I revise my statement. We let this one die and can revise it.
Okay.
Do you want to rescind it?
Is that possible?
Yeah, as long as Josh rescinds.
I'll rescind my motion.
I'll rescind my second.
So now we're in a phrasing thing. Okay.
Back to the language in 31 seconds.
Yeah. Okay, I'd like to make a motion to sustain the appeal by Thrive Hood River of the County Planning Department's tentative approval of an application for an industrial land use permit. On the grounds that the applicant has failed to meet the burden of proof under section 31.6A. Site access will not cause dangerous intersections or traffic congestion. That is my motion.
I'll second that.
It's been moved and seconded. Any other discussion? Okay, this time we'll take a vote. Commissioner Loomis,
Yes.
Commissioner Moore,
No.
Commissioner Guisto,
Yes.
is that a yes?
Yes.
Commissioner Lyman,
Yes,
Commissioner Derrick,
Yes.
Commissioner Kitts.
Yes.
The chair votes no, so that is 5-2. The appeal is sustained, correct?
And the application denied.
Yep, and the application is denied.
Motion for
A
the chair.
motion for me to.
Yes, I'd like to make a motion for the chair to assign, or for the chair to sign the
Denial.
denial.
Okay, is there a second?
Second.
All those in favor say aye.
Aye.
Anything else, sir?
That's it.
Okay, meeting adjourned.
Thanks.